Ladies and gentlemen, good afternoon. Thank you for inviting me to this forum. And as Sonia said, I will do some observations which relates mainly to my experience as litigator before national courts, but most of all before the Court of Justice and the General Court of the European Union. I will start my presentation dealing with the Italian system. Thank you. Okay. With the Italian system, as I am Italian and I moved to Brussels 15 years ago, so I am quite familiar with procedures in Italy, and I would like to start describing a little bit the experience of my country, because it is also a meaningful experience just to see how the regulation can change, can progress, and how important it is in any event to grant access to the judicial review, even if there is a mediation which is compulsory, because access to judicial review is a fundamental right that cannot be abolished by imposing to the parties an exclusive mediation resolution for disputes. In Italy, there are two main dispute resolution methods, court litigation and alternative dispute resolution, which include mediation, and we have this assisted negotiation, which in Italian is negoziazione assistita. And assisted negotiation is mandatory when the dispute concerns the reimbursement of the damage caused by vehicles and craft, a question of payment on the basis of any title when it does not exceed a certain amount, and now, after the Stability Law of 2015, also when the dispute concerns contract of transport or sub-transport. ADR is considered ultimate legal methods for settling controversies or disputes without having to resort to a lawsuit. As you see, alternative dispute resolution is considered compliant, is favored by the legislation when the litigation, the controversy, has a clear financial issue. Second slide. Mediation was introduced the first time in Italy in 2010, and it was defined by the legislator itself, and it was considered an activity carried out by a neutral and impartial third party, the professional mediator, with the aim of assisting two or more parties in reaching a possible amicable agreement and resolve a dispute. And you will see also, I imagine through the comments, observations from Paul, how important it is that mediator is neutral and impartial, and how the system, the legislative system, tries to ensure, to guarantee this impartiality and of the mediator. The mediation procedure must be executed by professional and independent, private or public mediation providers. And in Italy, there is an accredited registry which is maintained and also controlled by the Italian Ministry of Justice. So it is true that mediation, it is not judicial review, but I see a big effort from the Italian legislator to ensure that mediation is organized in a fair way. In October 2012, the Italian Constitutional Court declared unconstitutional the provision included in the legislative decree of 2010 that established compulsory mediation because the government had exceeded the scope of both the mediation directive and the law. And on this side, the Constitutional Court basically reproached to the Italian legislator to have exceeded the scope of mediation by depriving party to the access to judicial review, because the access, whatever is the regulation, the access to judicial review cannot be abolished by the legislative system regarding mediation, and this is really fundamental. Therefore, in September 2013, the Italian government reintroduced again compulsory mediation procedure. Yes, we are very tough. By means of Law Decree 69/2013, converted into law and established the new framework of rules regulating and promoting the use of mediation in civil and commercial disputes. Mediation was introduced in the Italian legal system with the objective of reducing the workloads and speeding up civil in-court proceedings. So in Italy, mediation developed basically because of the crisis of the judicial system. Next slide. So currently, there are 3 different types of mediation in Italy. We have voluntary mediation, when mediation is freely chosen by the parties and concern rights that are considered available. Judicial mediation, when the judge may order the party of a judicial proceeding, even for cases of non-mandatory attempt of mediation at any stage of the proceeding, but before the last hearing, to first try mediation, giving them 15 days to choose the mediation provider. Last, we have mandatory mediation, when a preliminary and mandatory attempt of mediation is imposed by the law and becomes a condition precedent to bringing a suit in the court. So mandatory mediation, this should be clear once more, does not mean that there is no possibility to have a judicial review, but it means that mediation is a precondition to have access to judicial review. Currently in Italy, the following matters are subject to mandatory mediation: neighbor disputes, property rights, division of a joint property, inheritance matters, lease matters, agreement whereby owners of a company or of a going concern transfers the shares or the business to a member of their family, medical malpractice, insurance, financial and bank contracts, or in the end, mediation becomes mandatory when it's provided in a specific agreement already drafted by the parties. When the mediation procedure is mandatory, the parties involved must be assisted by a lawyer. So the presence of a lawyer is fundamental, and parties can not negotiate on their own. The lawyer takes a responsibility because he has to sign the mediation minutes and agreements in order for them to be considered enforceable. So they become, as we say in Italy, titolo esecutivo, to start a new procedure. So this is quite important, because the fact choosing mediation does not mean does not mean that at the end of the procedure you do not have an enforceable title, because the main concern of the legislator in Italy was to offer parties who choose mediation to have an enforceable title at the end of the procedure. The proceeding for a mandatory attempt of mediation can last for a maximum of 4 months. Once the procedure has been initiated, 2 different scenarios can follow. The parties can reach an agreement, and therefore the signed minutes and agreement are enforceable, or the mediation can fail, and then any of the parties may commence a lawsuit. If one of the parties does not reply to the request of mediation, its behavior may be considered negatively by the judge in a case of lawsuit. So the party have to behave in an honest way while refusing the agreement during the mediation phase, because their behavior could be sanctioned by the judge later on during the judicial proceeding. Pursuant to the above, when the powers of attorney are signed, the parties' lawyers are required to inform their clients in writing about the mediation option and the financial incentives. Otherwise, the power of attorney may be voided. So this is quite, I think, a good measure adopted by the legislator, because this obliges us as lawyers to inform the parties that there is the possibility to go for mediation. And we have to do this at a very early stage when the party signs the power of attorney. So in the power of attorney, in Italy, we have to include this clause, and we have to testify, I would say, that we have been warning the parties about the possibility to go for a mediation procedure. Now, as we are in Belgium, I think we should say a couple of words also on the Belgian system. Most of all because Belgium already adopted the mediation proceedings, mediation in 2005, so at a very early stage before the adoption of the directive of 2008. And the provisions regarding mediation in Belgium are inserted in the General Code of Civil Procedure. So there is not in Belgium a specific law like in Italy, which is regulating mediation. But mediation, it has already been included in 2005 in the General Code of Civil Procedure. These provisions, already adopted by Belgium, were not amended after the adoption of the Directive 2008-52, as they were considered in compliance with the directive. And this is a merit, I think, of Belgian legislator. Mediation in Belgium is admissible in civil law, including family disputes, commercial law, employment law, victim offender, and restorative mediation. Generally speaking, recourse to mediation is a voluntary choice by the party, and there is no penalty if it fails. However, in a divorce proceeding, the Statute of April 2011 obliges the judge to inform the party on the possibility of mediation. Moreover, the judge may refer to mediation at any at any stage of the proceeding. And if a positive agreement is reached, the judge, upon request of each of the parties, may ratify it. So you see, while in Italy there is a more important role given to the lawyers, in the Belgian system, this function of warning the parties about the possibility to go through mediation is up to the, most of all, up to the judge. The agreement made under the supervision of an accredited mediator can be ratified by the court on request, even of one of the parties, and has the force of a judgment. So in both systems, Italian system and Belgian system, there was the concern of the legislator to make this kind of titles, which are the consequence of a mediation, enforceable. So the title, this agreement reached by the parties shares some characteristics of a normal, I would say, judgment. The judge can reject to ratify the agreement on the grounds of public policy or in family matters when the agreement is contrary to the interest of the children. And as I think it is quite a good rule for protecting superior interest, which should not be left to the only to the parties, but there is a need of a public control on the content of the agreement when, most of all, when there are also the interest of the children to be protected. The agreement has the effect of a formal notice, suspends the statute of limitation for 1 month, and suspends the prescription as long as the mediation proceedings last. In Belgium, there are 2 types of mediation, so it is a bit different from the Italian system, because there is voluntary mediation or judicial mediation. For both of these types of mediation, the parties shall choose a mediator appreciated by the Commission fédérale de médiation. If an agreement is reached, the judge shall proceed to its homologation and it will become enforceable. In Belgium, there are 3 categories of mediators. Mediator for family disputes, mediator in civil and commercial disputes, mediator in social disputes. And in Italy it is a bit different because, as I told before, there is only 1 category for mediators, while in Belgium mediation has been introduced running from 2005. So the system had the opportunity, had more time to progress and to reach this specialization for mediator, which I consider it quite important and meaningful in the Belgian system. Now I skip to another matter, ADR in proceedings before the General Court and the Court of Justice of European Union. I have experience of this kind of proceedings, so I would just like to bring to your attention some observations which I draw from my experience in the field. At EU level, forms of settlement agreements exist in a case of an infringement procedure pursuant to Article 258 and 259 of the Treaty on the Functioning of the European Union, a dispute between the EU and its agent pursuant to Article 270 of the Treaty on the Functioning of the European Union. And we can also have an arbitration clause pursuant to Article 272 of the Treaty on the Functioning of the European Union. And moreover, a mediation service is offered in case of disputes concerning intellectual property before the OMI, which is an agency of the Commission located in Spain, in Alicante. Just a couple of words on infringement procedures, even if as lawyers, as private lawyers, we will never be involved in this kind of procedures, because, as you know, these are procedures which concern the Commission and member states, or a member state and another member states. But I think it is important to look into this regulation, into these articles, provisions from the treaty, because you will see that the procedure is not started immediately by the Commission when a member state does not comply with superior European legislation, but the Commission issues a reasoned opinion against the member states, inviting the member states to comply with superior legislation, and only if the member state does not comply with superior legislation, the procedure, the infringement procedure, which is very heavy for a member state, will be started. So we can see also, as in the public sector and in public litigation, in litigation concerning only public bodies, there is a concern also in this field to push also public bodies to reach an agreement, a sort of agreement, even if the member states cannot negotiate for sure, they only have to comply with superior legislation, but there is this sort of attempt to solve the problem before seizing the Court of Justice. And now I would also like to spend a couple of words on litigation between the European institution and its personnel, because I have a large experience in the field. As you know, the jurisdiction in this field, the jurisdiction of the Court of Justice is the legal basis for this kind of jurisdiction is Article 2070 of the Treaty on the Functioning of European Union. And there is also a special provision in the staff regulations regarding officials in the European institution, which imposes really as pre-litigation step the ADR. This means that the Commission and or the European institution and the agent must try to reach an agreement before seizing the court. I must say that this pre-litigation step is usually, not. I had bad experience in this field because even if the European institutions are public bodies, they always try to negotiate as a private party, which should not be the case, because I consider that when there are fundamental rights or superior rights, a public body should always keep in mind the rule of law, even when negotiating. And most of all, I was a bit sad because I have seen the public institution refusing to reach an agreement, which is, and in the end, this kind of provision which tries to push the parties to reach an agreement before seizing the Court of Justice is devoid of any purpose, because only in 95% of cases, the answer from the European institution is absolutely negative. And so, in the end, there is this kind of pre-litigation steps has only the aim to, has no aim in the end, has no substantive object, and I consider it should be abolished by the European legislation. I close my presentation, and maybe you can ask some questions on this matter.
Thank you, Michela.
Thank you very much for your attention.